Now, Justice Aburili, or a High Court judge, has now said that one cannot be jailed beyond 67 years. Is that true? So this man is saying he was sentenced when he was 37 years. He has been resentenced from death sentence to 40 years. 40 years plus 37, he gets 77 years. He will walk out of committee when he's 77 years. When he says the life expectancy of Kenyans is 67 years, will he not be dead? Because he's sure he'll not be alive. This is the question that Justice Aburili was faced with. I know people will be mad, but that is the law. You can be sentenced to 100 years. You can be sentenced to 500 years. And yet, life expectancy in Kenya is 67 years. Welcome to trending version of the Court Helicopter stories. This one is a controversial diversion from what many of the media houses carried in their dailies or in their news. It went that now Justice Aburili, or a High Court judge, has now said that one cannot be jailed beyond 67 years. So if somebody is around 67 years, the import is that he cannot be jailed. Is that true? This is not true. Because this is about a controversy against what the public has been made to believe. I will give word to word, blow to blow, before I give my comment from Court Helicopter. This is a question that was before the Constitutional and Human Rights Division, petition number E802 of 2025. This is between James Wonga, the petitioner, and the Attorney General as the first respondent and the Director of Public Prosecution. This is a judgment issued by Justice R.E. Aburili on the 3rd day of August 2026. Introduction. James Wonga was originally convicted of a murder under Section 203, as read with Section 204 of the Penal Code in Milimani High Court Criminal Case number 10 of 2010, and he was sentenced to death on 3rd June 2014. He appealed to the Court of Appeal, but again he withdrew in case criminal appeal number 23 of 2018 to seek what is called resentencing after the Supreme Court had made a decision in Karioko Murwatetu and another. He withdrew that appeal. When he withdrew that appeal, he applied for resentencing in criminal petition number E282 of 2020. He applied for resentencing. In the Murwatetu decision, anybody who had been given a death sentence, you were to apply for resentencing. This man applied for resentencing. He first appealed, then he withdrew and went for a sentence. His death sentence was reduced to 40 years. That is the true facts of this matter. Then he filed this petition before Justice Aburili. He filed a petition dated 24th of November 2025. What was he seeking? In prayer 1, he wanted the judge to give a declaration that the sentence of 40 years imprisonment is degrading for fouling the filed report of about 67 years of human beings. So he filed before the judge. This is a constitutional petition, but these 40 years goes against the life expectancy of Kenyans, which the World Health Organization has put at 67 years. B, he sought a declaration that the constitutional rights of the petitioner under Article 19(2), 21, and 27 of the Constitution have been violated for subjecting him beyond the concept of normal life expectancy of human beings. So he said 67 is the normal life expectancy of every human being. Anything above that, it is a violation of his fundamental human rights. That is what he went before the judge. The judge looked at his arguments. In paragraph 4, the petitioner is saying he was born on 13th December 1977, making him 37 years old at the time of his sentencing in 2014. He argues that a 40-year term effectively keeps him incarcerated past the age of 77, which undermines the average normal life expectancy in Kenya profiled at approximately 67. So this man is saying he was sentenced when he was 37 years. He has been resentenced from death sentence to 40 years. 40 years plus 37, he gets 77 years. He will walk out of committee when he's 77 years. When he says the life expectancy of Kenyans is 67 years, will he not be dead? Because he's sure he will not be alive. He will not reach 77 years. He's basing his argument that Kenyans will live up to 67. So what have you given me? I was given the first death sentence. I appealed. You have given me 40 years. There is no difference between the 40 years you have given me and the death sentence. This is the question that Justice Aburili was faced with. Justice Aburili moves further and says, paragraph 17, in this present petition, it is clear that the petitioner already availed himself of that window of resentencing at the High Court. And the High Court exercised its discretion and resentenced him to serve 40 years imprisonment, substituting the death sentence. So the judge is saying, because this is about the question of legal technicalities, do I have jurisdiction to hear this matter? That is the question Justice Aburili dealt with. She never dealt with the 40-year issue. The judge dealt only on the question whether she has jurisdiction to hear this matter. Why? This man was sentenced by a high court to death sentence. Murwatetu came later and allowed this person to go to the same high court for resentencing. He went to this high court and he got a resentence of 40. Still not satisfied, he went to a constitutional high court. And that is what the judge is now dealing with. Listen to what the judge says. Once that substitute sentence was rendered, the court exhausted its statutory and constitutional jurisdiction regarding the resentencing of the petitioner. The court became functus officio. Under the law, once a judge has given a sentence, that judge cannot again hear the matter. The judge is complete, functus officio. Kwisha. Kalamu inavunjwa. We did an explainer. Kalamu ikivunjika, you can't go to the same judge saying, ile kalamu ulivunja when you sentenced me to 40 years, irudishe. That is what Justice Aburili is saying. In paragraph 19, the judge explains, under the doctrine of functus officio, a judge or a court having once performed its duty and delivered a final judgment, that judge or that court has no power to re-examine, to alter or reduce the sentence it or another judge of coordinate jurisdiction has passed. So the judge is saying, once another judge has given you 40 years, you cannot sneak to me, I'm also another judge. We are equal. I cannot listen to you. You go to the Court of Appeal. I am functus officio because another judge, similar position like me, gave you 40 years. He goes to say, in the absence of a statutory authority, this court is prevented under the doctrine of functus officio from rehearing a case where a final decision and a judgment have been made. Paragraph 20, the last one, I therefore find that this court lacks jurisdiction to reopen and entertain or interrogate issues of the petitioner's absence, which issues were fully determined with finality before the trial court in criminal case number 10 of 2010 and further reconsidered for resentencing in criminal petition number E282 of 2020. This is the judgment that was read virtually in Nairobi on the 3rd day of August 2026 by Justice R.E. Aburili, a judge of the Constitutional and Human Rights Division. Let me put it in simple terms. The judge never said that you cannot be jailed beyond 67 years. The judge simply said, I have no jurisdiction to hear this petition because that question had already been bypassed by the court that reviewed the sentence from death sentence to 40 years. Has this ever happened? Yes. In the case of the person who was claiming that he is a relative of Gachagua, he had been sentenced and a judge had already pronounced on the sentence. He had gone to the Court of Appeal. He had gone for resentencing and he made an application before Justice Muteti. The judge, Justice Muteti, saying he has no power he has no jurisdiction to entertain the matter. And the sentence that had been issued stood. What are the lessons in this matter? It is clear that you can be sentenced to death sentence. It is clear that you can be sentenced beyond the age of 67 years. So, anybody who is facing murder, you can get a death sentence. What did we get from Kisumu?
Otieno alias Daddy is hereby sentenced to death. On counts 2, 3, and 4, the accused Shem Akuku Otieno alias Daddy is likewise sentenced to death on each of those counts. However, the execution of the sentences imposed on counts 2, 3, and 4 shall remain held in abeyance for as long as the sentence of death imposed on count 1 remains in force.
Is that not more than 67 years? Yes. 2, listen, Justice Muya giving a life sentence to Major Mugure.
But the murders of the 3 accused persons I find were barbaric. The prosecution has called for death penalty. I am aware that the Muluatetu case has not made it illegal, but in the circumstances of this case, and in bearing in mind the time the accused person has been in custody, I sentence him to life imprisonment.
Therefore, there is no law that is going to save you, that because the life expectancy is 67 years, you are not going to be sentenced beyond that. If you are sentenced, because this might be the mitigating factors, Obado could have used that, look at my age, I'm this age, don't sentence me beyond 67 years. It falls flat. From Court Helicopter, we don't get it wrong. We bring it, controversial as it is. I know we have, Vivian got this authority. I know people will be mad, but that is the law. You can be sentenced to 100 years. You can be sentenced to 500 years. And yet, life expectancy in Kenya is 67 years. From the desk of Court Helicopter, Wakili Dan Senomari, getting it live as it is. Thank you.